I did ask another question actually of Sophie at Women's Aid. We're social marketers. We've spent the last 20 years working on social campaigns, which actually included domestic abuse, which was launched by Scottish Government 20 years ago. And one of the areas that we've picked up on the last 3 years, which we've worked unfunded on, is the contentious issue of parental alienation, where one parent is forced to relinquish that close living bond post-separation or divorce. So we aligned with many experts in the field, because that's what we always do. Everything we do is evidence-based, and undertook sort of a soft survey on our fairly innocuous child seat site, actually, among parents. And we were inundated with responses, over 2,000 responses, 1,500 plus from the UK, 43% women. So this is an issue that is not a gendered issue, where either parent, male or female, can actually work to separate a child following divorce through a range of what we would say are highly abusive behaviours. As I said before, I'm a survivor of domestic abuse, and I cannot think of anything more abusive than the systematic erosion of a relationship that a parent has with their own children. It's actually in the Women's Aid booklet what constitutes abuse. And if you look at it from an alienation point of view, repeatedly denigrating, demeaning and devaluing a parent, isolating the child and the other parent from the family, creating financial hardship where the parent is forced to go to family court. I've yet to meet, and we work now with over 10,000 victims. I've yet to meet a parent that actually wants to go to family court to fight for their children, spending 10, 20, 30, up to £300,000 trying to retrieve that relationship that they had prior to divorce, interfering with parental responsibility, making false allegations of abuse or fitness to parent or drug and alcohol abuse, interfering with parent time, destroying pictures and mementos that child has of their other parent, and burdening their children with angry, abusive outbursts when the child expresses the desire to see their other parent. So my question was this, Sophie, what in that would you say is not abusive? And why should it be removed then from the guidance notes of the Domestic Abuse Act?
Thanks, Janice, I think there's obviously a lot of detail in what you've just set out there. And I think for us at Women's Aid, it's not to say it's not abusive. I think our position is that the behaviours you've just described fall within coercive and controlling behaviour. And that's kind of, as you set out, that's kind of how we understand those specific forms of behaviour and types of abuse. Is it falling within coercive and controlling behaviour? And I think what we kind of saw through some of the debates on the domestic abuse bill, there are kind of very clear views on either side and very clear experiences on either side of this argument. And I think what is really critical for us at Women's Aid is that, kind of dependent on how you frame it, whether it be parental alienation or whether you view it within the coercive and controlling behaviour framework, is that none of this discourse or discussion does anything to kind of prevent those allegations of domestic abuse being taken seriously. Because I think that is what Women's Aid's research has shown time and time again through our Child First campaign, which is all kind of focused on ensuring that child contact is as safe as possible and has the child's best interests at heart, is that those allegations of domestic abuse are therefore not taken seriously and disregarded by the family courts. And I think that is always our main aim, is to ensure that those allegations aren't disregarded and we are believing survivors when they're brave enough to come forwards. And as I said, it's always for us about ensuring that the child's safety is the first and foremost consideration in the family courts. But it's just the framing, I think, is that we see it within that coercive controlling behaviour. And for us, that is quite clearly included already in the statutory guidance. And I think because there is such stark discourse on kind of the concept of parental alienation, we don't want it to have that potentially negative impact of affecting those allegations when a survivor is brave enough to come forwards and to kind of disclose and share their experience.
Well, thank you for that, Sophie. Would you not think, though, that the whole intent of the Domestic Abuse Act, as I understand it, was to try and make it easier for self-identification? That was clearly a government aim, in that abusers, those who are victims, are able to identify the behaviours, and therefore coercive control is undoubtedly, as you quite rightly say, an element of parental alienation. However, the specific behaviours of alienation are very distinct. And do you not think that by leaving those in, it helps that self-identification, which is so important, whether it's a victim mother or a victim father?
I suppose if I look at the current statutory definition of domestic abuse, it is incredibly broad. And I suppose the government wanted it to be as broad as it is to ensure it captured as many experiences as possible. So, we know that the definition doesn't accurately capture the experiences of Black and minoritized women because it doesn't include so-called honour-based abuse. It doesn't include forced marriage and FGM. So I suppose the government's intention to have that broad definition enables it to be captured within it. It's kind of, frontline services are still going to use their own specific definitions, but there is that statutory definition to raise awareness about domestic abuse, but it is so broad that other forms are kind of captured within it without being specified. And I suppose, there were kind of arguments of all the different forms of abuse that could be captured within that definition. We advocated for many other forms to be captured, but the government were very clear about needing it to remain that broad. So I suppose with the government's intentions around that, there was we're slightly stumped by that point, because then, we did want more recognition for other forms of abuse, but they wanted that broad definition.
So why specifically you would then want to remove alienating behaviours when you recognise it as coercive control? Why would you have such an objection to keeping that in? We know that there are tens of thousands of victims, so it's highly prevalent. Kafkas, England, deal with 140,000 plus cases annually. They reckon that 80% of the most contested cases have alienation prevalent. Their research in 2019 showed that 52% of those parents who were going for enforcement orders did not have any safeguarding issues, therefore no domestic abuse, and yet they were still being prevented from seeing their own children. So surely, as a compassionate society, we would want to protect those mothers and fathers affected and help their children to be able to benefit from both parents.
I completely agree. That is most definitely what we want to do. I suppose, as I set out earlier, it's the kind of the contention and the stark discourse around that term parental alienation, whereas we have specific legislation and a criminal offence around coercive and controlling behaviour. And even though that's been in place for 5 years, we know from the conviction rate that there is still much more to kind of ensure that the understanding of that specific form of abuse is understood. So it's very much kind of, as I say, agreeing that our aims are the same, but not wanting a contentious term to impact when a survivor comes forward and shares their experience, and that to be disregarded by the family courts because of that kind of contention. But as I set out, there are very kind of varying opinions on this.